Today we're going to discuss about the contract, especially people who are on H-1B and L-1 visas, and if they have contract with employers. Today, Ajay Choudhary is a very eminent lawyer, and he does mostly employment law with regards to the contracts, and he has a very good knowledge about immigration too. It's not that he's just a contract lawyer, he's very good in immigration too, and he's going to answer some of the questions that I have, especially when I need any help on the contracts. I go to him for my help though. Now, Ajay, we do have this contract with the employer and employee where the employee cannot join the end clients or vendors though. Is this contract enforceable though?
That's an example of a non-compete agreement.
Okay.
What happens in that situation is that there's lots of litigation about it. I mean, there's lawsuits filed left and right by employers, by employees around non-compete agreements. My suggestion would be, if an employer is trying to enforce a non-compete agreement, hire a lawyer, hire us, someone, to send a letter back to the employer saying, wait a minute, this non-compete is not enforceable. You're hurting us by trying to enforce it. You could owe us damages, and see either if they'll back down, or like a lot of these cases, maybe they'll settle. Maybe there'll be some resolution, some middle ground. Maybe they'll accept a certain amount of payment to make this non-compete go away. There's various ways that non-compete agreement can be attacked. For example, and we were just talking.
So, Ajay, we are speaking about the ABC Consulting
Sure.
and Company, and the end client is, let's say, Coca-Cola, in between Deloitte. So, of course, as we have been discussing, the contract is between me and ABC Consulting Inc., the employee in the ABC Consulting Inc. Then that means that they should not join according to the non-compete agreement with Deloitte or Coca-Cola in the scenario that we are speaking about. So do you want to attack that? How do you attack it? Yes.
Well, let's say the non-compete is saying that the employee cannot join Deloitte or Coca-Cola in any capacity. It doesn't specifically say they cannot work in a certain job title or profession. It just says you cannot join them for 2 years.
Mm-hmm.
That is an example of a way that the non-compete could very well be unenforceable and can be attacked, because in general, in order to be enforceable, non-compete agreements need to have a reasonable scope of activity limitation.
Oh.
And so this is an example of where the employer's non-compete agreement does not contain a reasonable scope of activity limitation if it doesn't limit the employee to the type of work that they're performing for the employer. Another example.
So for example, I'm working as a software developer. What you're telling is that the contract doesn't have a restriction that I should not work as a software developer. That may be very well be enforceable. But if it's broad that I cannot join in any position, then it can be easily attacked and we can win on that thing.
That's exactly right.
Having said that though, now my question to you, Ajay, is that what if I'm joining Coca-Cola with software developer? Can you still attack the contract?
There's other ways. In order to be enforceable, a non-compete agreement needs to have a reasonable geographic limitation.
Oh.
So for example, let's suppose that the employee is working for ABC in Houston,
Mm-hmm.
and then they end up going to Dallas
Okay.
to work for Coca-Cola or Deloitte.
Yeah.
That's a different city. If the non-compete is trying to stop them from working in a different city than where they're working for, for ABC, then that could very well be an unenforceable non-compete agreement. I've seen agreements where employers either do not have a geographic limitation in the non-compete, or they seek to bar the employee from working in the entire United States.
Based on the contracts normally I read though, I'm not an expert in contracts as you are, but what they say, they don't have any geographical location, they don't have any specific position that they can join. So yeah, that looks to be good that can be attacked.
Yes, employers miss that, and it's their burden if they want to make the non-compete enforceable to put that geographic limitation in. If it doesn't have one, then that could very well be a good ground for attacking the non-compete.
Now, Ajay, the practical difficulty that comes for us, Ajay, is that, so this ABC Consulting Inc., Deloitte and Coca-Cola situation though, as an employee, the employee is going to join the Coca-Cola though. The ABC Consulting Company is sending a notice directly to Coca-Cola and telling that it's a tortious interference of contract. And Coca-Cola immediately tells, no, I don't want you anymore. What's the solution for it?
That's understandable. I mean, Coca-Cola doesn't want to get involved in litigation and they may be a little bit scared off. So in that scenario, my suggestion would be the employee should hire us or any lawyer to write a letter to ABC saying, you need to cease and desist, withdraw this letter, let's come to an agreement on this non-compete, or you are going to owe us damages for taking away this employment opportunity from us, tortiously interfering with our chance and the employee's chance to make money with Coca-Cola, and here are the reasons why this non-compete is unenforceable. At that point, hopefully, maybe ABC will be scared off. Maybe that once they receive the letter from the lawyer, the ABC will be scared off, or maybe they'll enter into some sort of settlement discussion to say, okay, let's work this out. You pay us X amount of dollars or perform some extra work for us, and we can agree to tear up this non-compete, and we'll also then inform Coca-Cola that we're withdrawing the non-compete.
Okay, that's good. So if somebody wants to contact on the contract says, don't contact us, it's going to be Ajay who is going to be there. I'm going to put a link at him. He's been practicing immigration and contracts law for a long period of time, almost 20 years.
More than 20 years.
More than 20 years. I know you only from 22 years, yeah. So you can contact, we'll put a link out there. There are some clauses in the contract that I noticed that especially when H-1B and L-1 employees, where the clause says that if you leave the employment within 6 months or 2 years after you join my company, you have to pay a liquidated damage of $20,000. Is that enforceable, especially on the H-1Bs?
Liquidated damages, it's a gray area. In order to be enforceable, normally a liquidated damages provision needs to be a reasonable estimate of the damages that the employer would suffer. So for example, let's suppose that the employer's liquidated damages provision says this penalty of $20,000 needs to be paid regardless of when you leave. Let's say you leave after 1 year or after 2 years, after 3 years. That, in my view, and in the court's view, would tend to make the liquidated damages provision unenforceable because it's not being prorated. In other words, the sooner the employee leaves, the more theoretical damage the employer is suffering. They have to retrain someone. But if the monetary amount is not being changed based on when the employee leaves, then it could very well be unenforceable. And a lot of employers are not going to take the time, in my view, to prorate it and take the time to put that in the contract saying
first 6 months it's going to be 10,000, next 1 year it's going to be 5,000, 2 years it's going to be 2,500. They don't put that kind of thing.
Exactly. So that's one way that this liquidated damages clause can be attacked.
Can be attacked with saying that they're taking the wages back with filing a WH-4 complaint with the DOL. Can you explain that process?
There are the regulations from the Department of Labor do say that liquidated damages clause, if it's a valid clause, can be enforceable.
Okay.
But it does say that when it crosses the line into a penalty, if the liquidated damages clause is actually a penalty, then it's not enforceable. So and whether it's a penalty or whether it's liquidated damages, a valid one, depends on state law. So it's a little bit of a gray area, but this prorated argument in general has been accepted throughout many states. So a lot of employers are not going to be sophisticated enough to differentiate the penalty or the amount that should be paid based on when the employee leaves. So that argument, I believe, can help to invalidate the non-compete.
Ajay, to be practical, is there a chance that I can go to the Labor Department and complain against this company if I see that the liquidated damages are unreasonable?
Yes.
And what is the best method of doing it?
There's a complaint form.
You're speaking about WH4.
Exactly.
We're going to put a link of the DOL website in the link of this video. Please look into the WH4 form. And what we notice is that if and when the employers try to enforce any of the contract, though, if you just fill the WH4 and then you show it to them and saying that, look, if you don't back off, I'm going to complain to the Labor Department, and then the employer normally backs off, is right?
Exactly. And the employer, if they don't back off, and maybe this is why they do, they can actually be barred from future H-1Bs. Yeah, so they just to save themselves from having a future headaches, they may back down.
Yeah, what I've noticed that is that when the WH-4 has been hit on the company just drops everything off. So
Correct.
please, if you want to use it when the employer is attacking, you may consider that very seriously, though.
And just one point, in the law, Department of Labor regulation says that if someone does complain, file with it, they're protected from retaliation. So if the employer doesn't back off and retaliates against the employee, there's another complaint that can be filed.
That's good. And there are some employers that won't give a H-1B approval unless you sign a contract of liquidated damages of $30,000. They won't give the approval even though H-1B is approved. Is there any way out for it?
My strategy in that would be for the employee to file a WH-4 complaint, or at least send a letter in something in writing to the employer identifying what the employee believes is some reasonable violation that the employer has committed, either an improper deduction, not giving enough the proper wages. It doesn't have to be an actual violation, but something the employer has done that is violating it. And then also in that letter, put in their request, also I request a copy of the approval notice. Then if the employer fails to give the approval notice, you can then file a complaint with the Department of Labor saying that the employer is retaliating against the employee
By not giving the
approval notice, and then that's a legitimate complaint you can file with the Department of Labor. And at that point, there's a good chance the employer may just back down and give the approval notice to avoid dealing with the Department of Labor.
I've had situations, Ajay, where people are telling to sign the contract that for $30,000, if I leave the employment within 5 years after the I-140 is approved, what are the chances of the employer enforcing that $30,000? And how do you defend them if you are the lawyer?
There's a court decision. There's not many court decisions on this particular issue, but there is a court decision that I believe is helpful. In this case, there's an employer, Chemtex. They filed I-140 for their employee, Renuka Polymera. Now,
I'm the lawyer for it, actually, for Renuka. Go ahead.
I did not know that, by the way.
Yeah.
And the Renuka signed a contract, an agreement, saying that she would pay back $20,000 if she left the company within 2 years, or if she was fired for cause within 2 years of when she got the green card. Apparently, and I don't know if this is true, exactly true or not, it was reported in the court session, but apparently the employer fired her for cause. And then the employer sued her for the $20,000 that she was supposed to pay them according to the contract. Now the court held that that $20,000 provision was not enforceable. And here's the two reasons that the court gave. One, the court said that there was not adequate consideration for Renuka's promise to pay the $20,000 back. Let me explain that. In contract law, in order for a contract to be binding, each side needs to receive something of benefit, or the contract is not binding. That's just basic contract law. That's called consideration. Here, the contract said that the employer, Chemtex, is saying, we will continue to employ you and we will continue to sponsor you if you sign this contract. And they said that is the consideration, that the benefit that the employee is receiving.
That's the employer argument.
Yeah, the employer argument. But illusory promises are not valid consideration. And under the employment at will doctrine, which is the doctrine in most states, an employee and employer can terminate the employment relationship at any time for almost any reason. So in other words, an employer is saying as part of this contract, we will employ you and we will continue to sponsor you. That is a illusory promise because it's not enforceable. The employer can turn around the next day and end the employment relationship under the employment at will doctrine. So the court said that is not adequate consideration for Renuka's promise to pay back $20,000. Therefore, there's not a binding contract. Therefore, the contract provision is unenforceable. That's one reason. A related reason, it goes back to the employment at will doctrine. The court said that the liquidated damages clause that says that Renuka has to pay back $20,000, that violates the employment at will doctrine, because the employment at will doctrine, the principle of it is that the employee or the employer can end the employment relationship at any time without fear of, and without being liable for future lost wages. Otherwise, what's the point of the employment at will doctrine if you can fire an employee and then they can sue you for breach of contract, say, for future lost wages. It contradicts the employment at will doctrine. So the court said the liquidated damages clause is unenforceable because it violates the employment at will doctrine. So I think if this happens to anyone else, they can cite this court decision in a letter from a lawyer such as us or any lawyer to the employer and say, look, this court decision says that this type of clause is unenforceable. Back off. I'm not going to pay you this $20,000. And there's a good chance the employer will look at this court decision and realize that, you know what, if they file suit in court, there's a good chance they're going to lose, and they may just back down.
One of the other things that pops up with these consulting companies, Ajay, is that they don't pay the last 2 months of their salary. How do we collect that? I mean, when they leave to the different job and they don't pay the last 2 months of salary.
Again, file a complaint with the Department of Labor.
So WH-4.
Exactly.
Do you recommend going through a lawyer or just file a WH-4?
Either way, I mean, it's successful either way a lot of times.
I normally suggest, Ajay, is for the employee, I mean, correct me because I'm not a contract lawyer, is to prepare the WH-4 form and don't send it to the Department of Labor, because sometimes what happens is that when you send a WH-4 form to the Department of Labor may come and inquire about the entire company. The entire company might wind up closing because there may be a lot of other problems.
Sure.
My client doesn't get the money and the company gets closed. So I tell them, look, don't send it to the Labor Department. Threaten your employer, send a WH-4 form, and if they don't pay, then you go and file a complaint.
That's good advice. And since you're only talking 2 months' salary, I mean, a reasonable employer would probably back down in the face of this. But I think that's a good step.
And if they don't, then you definitely they might end up closing the company, and yeah, we may still get the salary. We may not get the salary, but they may end up closing the salary.
Correct.
Anything else you want to add, Ajay? Can you? How do people can contact you?
Well, our website is kchoustonlaw.com. You can also contact Rahul Reddy.
We'll put a link for Ajay Choudhary's web link there, where you can go and make an appointment with him. And Ajay, can you explain more about how long you've been practicing?
Sure. It's been about 25 years that I've been practicing. I'm board certified in labor and employment law. I've also been doing immigration law this entire time. I've dealt with Rahul for many years. So we've got a lot of experience in this field.
So Ajay is not only just a contracts lawyer, he has knowledge about immigration, LCA, and other things. So definitely, if you have any contract issues, he has both knowledge. So that's going to be a very good guy to contact when employer is not paying, when you want to walk out of the contracts for the non-compete, when you have a contract where you have to pay the money liquidated damages, when you have a contract that you cannot leave the company with unless you pay $30,000 after your I-140 is approved. These are all the things that I normally refer to Ajay, and is very good to take care of those things.
Great.
Thank you, Ajay, for coming in. Thank you.
Thank you.